Order. The clerk will now proceed to read the orders of the day.
Item 1, Endangered Species Import and Export Amendment Bill, second reading.
Minister for National Development.
Mr. Deputy Speaker, on behalf of the Minister for National Development, I am back to move that the bill be now read a second time. Illegal wildlife trade threatens the survival of endangered species and harms habitats and ecosystems around the world. Singapore is committed to the global fight against illegal wildlife trade. As an international trading hub, we take this issue very seriously. We are signatory to the Convention on International Trade in Endangered Species of Wild Fauna and Flora, or CITES in short. CITES ensures that international trade in wildlife and plants does not threaten the survival in the wild. We have also put in place a whole-of-government enforcement framework and work closely with regional and international partners to stop illegal wildlife shipments from passing through our borders. For example, through our close collaboration with our counterparts in China, we seized a record haul of elephant ivory passing through Singapore in 2019. The ivory was worth more than 170 million Singapore dollars, and it came from more than 300 African elephants. Our efforts also helped the Chinese authorities to arrest 14 suspected criminals. Last August, we opened our Center for Wildlife Forensics to enhance our science and research capabilities in collaboration with international partners and local experts. Recently, our studies with Professor Samuel Wasser from the University of Washington found that most of the large ivory seizures made globally over the past decade came from repeated poaching at the same location and even from the same families of elephants. Such insights help us better understand the patterns and networks of illegal wildlife trade, and we share them with our international partners to facilitate cross-border enforcement. This will help source countries to focus on tackling elephant poaching hotspots and the illegal export of ivory, and destination countries to curb consumer demand for ivory products. The Center for Wildlife Forensics was also recognized as a CITES reference laboratory in June. This recognition is a testament to Singapore's capabilities in wildlife forensic science in supporting the implementation and enforcement of CITES. It also attests to the high standards of the Centre in conforming to ISO quality assurance standards for wildlife forensic testing. With this, we can help other CITES member states carry out wildlife forensic analysis on top of sharing our experiences and expertise with them. This will aid in investigating and prosecuting illegal wildlife trade cases more easily. Together, we can strengthen our efforts against the criminal syndicates and networks that conduct illegal wildlife trade. And within Singapore, we also continue to partner key stakeholders and the community to raise awareness on our roles in tackling illegal wildlife trade and protecting our planet's biodiversity. This includes regularly engaging industry stakeholders, such as the maritime industry, e-commerce companies, and financial institutions, and reaching out to the wider public through outreach and education programs, such as webinars, exhibitions, to better understand their roles in tackling the illegal wildlife trade. For example, just this March, our volunteers under MPark's Youth Stewards for Nature program organized the World Wildlife Day Regional Youth Symposium, which brought youth around ASEAN region together to discuss ideas and solutions to tackle illegal wildlife trade in Southeast Asia. And these are some of the steps that we have taken to combat the threat of illegal wildlife trade. But this threat is constantly evolving because illegal wildlife trade is so profitable. Smugglers are constantly looking for loopholes to exploit. So beyond strengthening our research capabilities, partnerships, and engagements, we must ensure that our regulations and enforcement tools remain up-to-date and effective. The Endangered Species Import and Export Act, or ESA for short, is a key legislation that supports Singapore's regulation of trade in the wildlife species protected under CITES. It gives us the power to take enforcement actions against illegal traders. For example, through the ESA, we have established a domestic ban in ivory trade since last September to support international efforts against the illegal trade in elephant ivory. We are now proposing to amend the ESA to strengthen our regulations for the trade of CITES species and to enhance our penalties and enforcement powers against such illegal trade. In drafting these amendments, we consulted a wide range of partners and stakeholders, including traders, shipping companies, industry associations, academics, and non-profit organizations. I would like to thank all of them for their valuable suggestions. Last November, we also embarked on a public consultation on the ESA amendments and on Singapore's approach to combating illegal wildlife trade. We have carefully studied the feedback received and incorporated relevant suggestions in our amendments in the bill. This includes additional amendments to make the Act more effective and more closely aligned with relevant domestic and international laws on endangered species. Mr. Deputy Speaker, sir, let me now take members through the key features of this bill. This bill seeks to amend the ESA in 4 key areas. First, to strengthen Singapore's regulatory regime for trade in CITES species. Second, to align the ESA more closely with CITES resolutions. Third, to introduce stiffer penalties for illegal trade for CITES species. And fourth, to strengthen MPAC's enforcement powers so that it can tackle illegal wildlife trade more effectively. Let me now go through each of these areas in turn. First, on our requirements for CITES species traded in Singapore. Currently, traders are required to produce a CITES permit or certificate when importing, transiting, exporting, or re-exporting CITES species in Singapore. This allows MPACs to verify that the trade in these species is legal, sustainable, traceable, and in line with CITES requirements. We are making amendments to the ESA to provide greater clarity for all stakeholders, in particular on the requirement for the transit of CITES species through Singapore, and the documents required for such trade. First, we will amend the definition of transit in the ESA to make clear that when CITES species are considered to be in transit in Singapore. Today, the ESA states that for CITES species to be considered in transit in Singapore, the species must, among other things, be brought into Singapore solely for the purpose of taking it out of Singapore. We recognize that ESA could be clearer on how this sole purpose requirement is to be satisfied, such that there's no ambiguity on when species are considered in transit. Clause 3 therefore replaces this requirement with a stipulation that traders who bring CITES species in transit through Singapore must, among other things, provide MPACs with a document that specifies a port, airport, or any other place outside Singapore as a destination of the CITES species. This document must also be issued on or before or within 14 days after the date on which the CITES species is brought into Singapore. Traders can provide a bill of lading, airway bill, or seaway bill, which state the final destination of the CITES species transported. These are among standard transport documents used in international shipping today. A list of the accepted documents will be prescribed in subsidiary legislation. Second, we will make clear the permits that traders need to obtain from the countries of export, re-export, or import for CITES species in transit in Singapore. Today, traders are required to produce CITES permits for CITES species transiting in Singapore. Where the countries of export, re-export, or import are not CITES parties, written permission, which is not defined in the Act, can be produced instead. This is for MPACs to verify that the species have been legally exported and will be accepted by the country of import. To ensure that MPACs receive the information it needs for such verification, Clause 4 makes it clear that the permits, certificates, or any other similar documents submitted must contain information that will be prescribed in subsidiary legislation. Where the countries of export, re-export, or import are CITES parties, traders should continue to present valid CITES permits or certificates containing the prescribed information to MPACs. Where these countries are not CITES parties, traders will be required to present valid permits, certificates, or any other similar documents containing the prescribed information to MPACs. The prescribed information will include details of the competent authorities approving the export, re-export, or import of the CITES species, as well as the scientific name, source, and quantity of the specimens traded. With these amendments, we aim to provide greater clarity on the requirements for the transit of CITES species in Singapore. Traders will not have to make significant changes to the existing business operations. But following these amendments, we will be better able to differentiate between CITES species which are meant for import into Singapore and species which are meant for transit. MPARCS can then take appropriate enforcement action against those who illegally import or transit these CITES species. Let me now move on to the second area of the bill, on how our amendments will align the ESA more closely with CITES resolutions. The amendments will strengthen Singapore's existing strict stance against illegal trade in CITES species. CITES resolutions provide guidance and recommendations on how CITES parties should interpret and implement CITES rules and regulations on wildlife trade. As a responsible CITES party, we follow the CITES resolutions closely where they apply to us. At the same time, we continue to ensure that trade can flow freely and easily so that we maintain our status as a global trade hub. For example, MPARCS issues CITES permits for CITES species exported, re-exported, or imported in Singapore in accordance with the permit requirements set out in the relevant CITES resolution. This ensures that our permits are recognized and accepted by other CITES authorities. We are now amending the ESA to ensure that our laws are even more closely aligned with these CITES resolutions. Clause 2 amends the ESA to make clear that our regulations apply to hybrid animals of CITES species, as though they are full species. These are animals whose recent lineage include species listed in CITES Appendix 1 or 2, including species that are either threatened with extinction and species for which trade is regulated for their continued survival. Taking the Bengal cat as an example, the Bengal cat is a cross between the wild Asian leopard cat and a CITES-listed species and the domestic cat. CITES permits are required for the trade in Bengal cats, which have a wild Asian leopard cat ancestor in their lineages, up to 4 generations that precede it. Although the ESA doesn't currently explicitly require this, our traders have been producing such permits when trading Bengal cats. Clause 2 also makes clear that urine, feces, or ambergris are not regulated under the ESA. As these are waste products naturally excreted, their collection does not threaten the survival of any CITES species in the wild. That brings our regulations on the trade in animal parts or derivatives more in line with CITES recommendations in this area. Lastly, Clause 4 and 5 make clear that permits, certificates, or any other similar documents issued retrospectively after the date of export or re-export of the CITES species or that contain unauthorized alterations are not accepted for the trade of CITES species in Singapore. Retrospectively issued documents can only be accepted if the documents are for trade in CITES Appendix 2 or 3 species and the circumstances that led to the retrospective issuance were not caused or contributed to by the trader. This amendment will strengthen enforcement against those who trade in CITES species without valid permits or other documents. Mr. Deputy Speaker, sir, I will now touch on the third key area of the bill, which is to introduce stiffer penalties for endangered wildlife trade offences under the Act. We last enhanced the penalties under the Act in 2006. However, the value of smuggled endangered wildlife has continued to rise over the years. For example, in 2019, we seized a shipment of around 12 tons of pangolin scales. They were worth $48 million, as well as around 9 tons of elephant ivory worth over $17 million. Thus, after careful review and consultation with stakeholders and the public, and considering the latest domestic and international laws on endangered species, we will enhance our penalties further to keep pace with the times and to increase deterrence against illegal wildlife trade. We increase the fines and jail terms that can be meted out to individuals who illegally trade in CITES species. Clause 4 increases the maximum fine for illegal trade in Appendix 1 species from 50,000 to 100,000, and the maximum imprisonment term from 2 years to 6 years. Clause 4 also increases the maximum imprisonment term for illegal trade in Appendix 2 and 3 species from 2 years to 4 years. Wildlife trade offences in relation to Appendix 1 species have stiffer penalties, as these species are threatened with extinction, and the impact of illegal trade on their survival is much more severe. We will also increase our penalties for the domestic trade in CITES species to align with that for international trade. That means that individuals who illegally sell CITES species such as rhino horns, tiger parts, and elephant ivory in Singapore will be subject to the same high penalties. This is to enhance deterrence and reflect a similarly strict stance against the illegal domestic trade of endangered species. Offenders that are corporations, unincorporated associations, or partnerships who illegally trade CITES species will also be subjected to higher penalties than individual offenders. This is because such entities generally have more resources and the means to move larger quantities of illegally traded CITES species compared to individuals. Clause 4 will also amend the ESA to increase the maximum fine for corporate offenders who illegally trade in CITES species up to $200,000 for each specimen of an Appendix 1 species and up to $100,000 for each specimen of an Appendix 2 or 3 species. We will also introduce higher maximum imprisonment terms of 8 years for Appendix 1 species and 6 years for Appendix 2 or 3 species to penalize individuals within corporate offenders such as directors or managers more strictly. We will also raise the maximum aggregate fine further across the board for both individual and corporate offenders to match the market value of all illegally traded CITES species comprised in our offence. This ensures that the penalties are proportionate to the potential gains from illegal trade of such CITES species, which have risen over time. The maximum aggregate fines for individual offenders will be set at $500,000 or $1 million for individual and corporate offenders, respectively, or the market value of the CITES species at the material time of the offence, whichever is higher. For example, in 2020, a South African trader was sentenced to 17 months of jail for transiting through Singapore from South Africa to Vietnam with 22 kilograms of rhinoceros horns without a valid CITES permit. As rhinoceros horns are worth about over $30,000 per kilogram, the offender could face a maximum aggregate fine of $760,000 if he had been subject to the stiffer penalties in the bill instead of the $500,000 today. At the same time, Clause 10 will amend Section 17 to penalize any person who misleads authorities. Today, the ESA only penalizes false but not misleading statements or documents. For example, a trader applying for import permit may deliberately mislead NPARC officers by providing once legitimate supporting documents that have since been revoked by the document issuer. These changes will enhance our ability to take enforcement action under the Act against individuals or entities who mislead the authorities. Apart from these enhancements, the bill also provides greater clarity to existing penalties in the Act. Currently, the Act provides for fines for illegal trade offences to be issued for each CITES species. This is currently defined to mean any animal or plant specified in the schedule of the Act. Clause 4 does not change the current position, but makes it clear that the fines are levied on a per specimen basis. In other words, the offender would be fined on the basis of each specimen of the CITES species, such as each piece of rhinoceros horn or elephant ivory comprised in the offence. Taken together, these revisions to the penalties will serve as a strong deterrent and enforcement against illegal trade in wildlife. Lastly, the bill will also make other changes to clarify and strengthen NPARC's enforcement powers and facilitate investigations on illegal wildlife trade offences. First, the amendments will enhance NPARC's powers to seize items under the Act. For example, if NPARC seizes a shipment of non-CITES timber blanks with illegally traded elephant ivory concealed beneath those blanks, the current ESA only allow MPARC to seize the elephant ivory. Clause 6 makes clear that MPARCs may also seize items that are used to conceal the CITES species, in this case, the timber planks. In addition, under Clause 9, conveyances such as cars and vans that were used to commit a wildlife trade offence may also be seized. These changes will further deter against illegal wildlife trade, as would-be smugglers will stand to lose their vehicles as well as any additional cargo that was used to commit the offence. Nonetheless, we recognize that there must be safeguards to expanded powers in respect to conveyances. Under Class 9, large conveyances of more than 200 tons net and aircrafts and trains used for regular passenger service to and from Singapore, as well as conveyances that were used unlawfully without the owner's consent, may not be forfeited. In addition, courts may only order the forfeiture of other conveyances if a person was convicted of an offence under the Act, and the conveyances was used in the commission of the offence. Clause 9 also introduces amendments to the forfeiture framework in the ESA. Currently, the ESA allows the mandatory forfeiture of CITES species and other items upon conviction for illegal wildlife trade offences under Section 4 or 5 of the Act today. Clause 9 replaces such mandatory forfeiture with court-ordered forfeiture in criminal proceedings. This will also apply to any offence under the Act. The bill also updates provisions to align the Act with other recent legislation, including the Wildlife Act, which came into force in 2020. For example, Clause 12 will introduce protections against liability for MPARC's authorised officers if they had acted in good faith and with reasonable care in the execution of any power or performance of any function under the Act. At the same time, the amendments will enhance MPARC's operational efficiency and investigative capabilities, as well as facilitate its prosecutions. For example, Clause 8 will allow MPARC's authorised officers to be accompanied or assisted by persons, such as auxiliary police officers in their inspections, searches, and seizures of premises or shipments of goods. MPARC's authorised officers will also be allowed to dispose of perishable seized items, such as turtle eggs, under Clause 6 to avoid incurring unnecessary storage and maintenance costs. Relatedly, Clause 12 allows for documents produced by authorised MPARC's officers to be admissible as evidence and taken as factual unless proven otherwise. Lastly, Clause 12 will insert new protection for informers by allowing for non-disclosure of information during the court proceedings that might lead to the identification of an informer. This is to encourage more individuals to provide information regarding illegal wildlife trade, given that MPARCs often relies on tip-offs to enforce against illegal wildlife trade and smuggling. In conclusion, Mr. Deputy Speaker, Sir, this bill is important as it strengthens Singapore's regulatory and enforcement regime for the trade in endangered species. It reflects our firm commitment to tackle the global issue of illegal wildlife trade as a party to CITES. The amendments will enable us to continue taking effective action against illegal wildlife trade as it evolves over time, for example, from brick-to-mortar to virtual markets. In 2021, MPARCs seized more than 90 animals that were being sold online as exotic pets in an island-wide raid. This included several CITES species, such as a Burmese python and tarantulas that had been illegally imported. 13 individuals are currently under investigation for the sale of these animals. We will continue to monitor and enforce against the sale of illegally imported CITES species, which will in future be subject to heavier penalties under the bill. The amendments are also largely aimed at strengthening MPARC enforcement against illegal wildlife trade, the smugglers, and errant traders. And any offence made out under the Act will depend on investigation findings of each case. For a large majority of the industry who have been responsibly following the requirements in the trade of CITES species, the amendments will have minimal impact on the existing processes of business operations. And we thank you for your cooperation and for doing your part to safeguard our Earth's natural heritage and environment. And everyone can play a part in combating illegal wildlife trade and in protecting our planet's biodiversity. For example, when buying a pet, do patronize licensed pet shops and ask the sellers for a CITES permit if you are buying a CITES species, such as dragonfish, or sulfur-crested cockatoo. Do also refrain from buying items which may contain endangered animal or plant parts or illegal wildlife products such as elephant ivory. Together, we can reduce the demand for endangered wildlife and contribute towards stopping the illegal wildlife trade. And let me round up by emphasizing again that Singapore is resolved in our fight against illegal wildlife trade, and this is a continuous effort and in partnership with the international community. We will continue to play our part to safeguard Earth's natural heritage, not just for ourselves, but also for our future generations. Mr. Deputy Speaker, sir, back to you.